Welcome to Notable Approvals. Ooh, I am attorney Amanda Shaffer. A couple of announcements before I get to our case today. First, don't forget to like us and follow us on Facebook and Instagram, YouTube, so that you don't miss any of our lives or of our informative and helpful videos. Next, this is another reminder. Tomorrow, April 14th at 9 p.m. Eastern Time or 6 p.m. Pacific Time, we will be having episode 6 live of Are You Smarter Than a Naturalized Citizen? We have 2 more attorneys going head-to-head to see who could pass the naturalization test first. I invite everyone to join us. It was a lot of fun so far, and especially if you are taking your naturalization test soon or thinking about taking it, you'll get an idea of what the questions are like because they're the actual questions and answers from the USCIS test. So again, if you like us on our Facebook page, you'll see the event. So make sure you have all that ready to go so you don't miss out. And you can check out past episodes on our Facebook page, YouTube, and on Instagram. All right. So let's get to our case today. This is a client who is a native of Jamaica and was a citizen of Jamaica. He's now a U.S. citizen. And this case is a very interesting case that I definitely wanted to talk about. So this client became a conditional resident in 2000. Oh, I wrote 2021. That's not right. It was 2012. A little dyslexia there. Okay. So he became a conditional resident when he was in 2012 based on his mother's marriage to a U.S. citizen. So he was a derivative on the application. And I think I actually talked about his mom's lawyer too, talked about his mom's case at some point. But essentially what happened is that his mom, unfortunately, was a victim of some very bad abuse. And I didn't meet her until after the first I-751 was denied. So if you're watching and you're confused, when you were married less than 2 years at the time of your immigrant visa interview or your adjustment of status interview, you only get a 2-year green card. And then within the 3 months before your 2-year green card expires, you have to file what's called a petition to remove conditions on residence, which basically you're proving to the U.S. government that it's a real marriage, you're still married, you're still living together. And if it gets approved, you get your 10-year green card, no more conditions. If it gets denied, well, then you are more likely than not facing removal proceedings. So in this case, they had filed jointly, but things just kept getting worse. When I met her, she was in the middle of a family court proceeding with a family offense petition, which gets you a restraining order, order of protection. I ended up taking over that part of the case too. We got her divorced, but we weren't so concerned about that. What we were concerned about was obviously making sure she was safe, getting that order of protection, which we got, and then getting the conditions removed on her residency and her son's, because he's directly tied to her. So if hers were to get denied, there's nothing he can do, and he's not going to have status. So it's a pretty stressful situation when you have kids that are riders or derivatives on your application. So, and then the other thing was they're facing deportation, of course. It's very common. In fact, it's surprising when it doesn't happen. When someone's I-751 gets denied, they're usually very quickly put into removal proceedings, which means the government's trying to deport them. Now, in some situations, it doesn't. I've definitely had people tell me, mine was denied 2 years ago, and I'm still here and not in removal proceedings. It happens. I tell those people you're very lucky, but you can expect that if your I-751 is denied, because that's their whole test on, is this a real or a fake marriage? They're making you reprove it 2 years later. So they were facing deportation, and I went to court with them and everything and told the judge that, so when you have your I-751 denied, no matter what basis you file it under, you can ask the judge to give it a second look, re-adjudicate it. But that doesn't work if you're no longer with the person. And the person literally could have to testify under oath about your relationship. When I say person, I mean your spouse. So when you're, subject to abuse, there's a waiver ground, there's a hardship waiver ground. I've talked about all of these in previous slides. If you go and check out other notable approvals, all the different types of waivers that you can have. Even with the abuse, though, you still have to show that it was a real marriage. So we told the judge we are refiling the I-751 with the abuse waiver. And back then, I believe, that was already with Trump. So they wouldn't administratively close the case, even though USCIS is the one who makes the decision on the I-751, not the judge. The only time the judge does is if it's denied and you ask them to review it. So what it means is that you go to immigration court, you have an application pending, but it's out of the judge's hands, it's out of the DHS's hands. You can wait. I've had these problems waiting for a really long time before with USCIS, but they used to kind of close your case and say, okay, when you finally get your green card, 10-year green card, when you finally get it approved, do a motion to terminate. And that's how we did it in the old days. And fingers crossed, we'll get to do that again. But at this time period, we couldn't do that. So what that meant was that the judge is going to just push your case out. So I don't remember how many times I went back with them. I don't think it was more than 3, but essentially what happened was, they give you like a year, even though, hoping it would be done in a year. You go back to court, you tell the judge, we're still waiting. And the judge pushes it out again. And that's kind of what happens. And then we did file a motion to terminate once it was finally granted, putting copies of their green cards. And then the judge granted the motion, so they didn't have to go back to court, at least for the final time. So that got off a little off topic from the naturalization case, but I always think that's an important thing to explain about these marriage-based green cards. A lot of people don't understand them that well or how it works, and that was a quick kind of explanation, including with immigration court. But if you do have any questions about what I said or about your case, this entire time, my phone number, email address will be scrolling along the bottom of the screen. Please do not hesitate to reach me. I'd be happy to help you. So after their 10-year green card was granted, both mom and the son wanted to apply for citizenship. So it was granted, it was granted in 2017, the I-751. And because they both had their green card since like 2012, they were automatically had enough physical presence as a permanent resident to apply for naturalization. Because those 2 years or 2 years plus that you're waiting for the 10-year green card do count towards the clock for naturalization. Now, another thing to keep in mind, because both of their 750, well, it was only one 751, he was on hers, but because his 751 and her 751 was granted based on abuse, they actually could have applied for citizenship after 3 years, because it's the same thing as if you're still married living with the spouse. However, it took so long for everything to get adjudicated, they already qualified for the 5 years, so it didn't matter. So in 2018, we filed naturalization for mom and son, and mom had a pretty quick turnaround time. It was June 2018 we filed it, and then January 2019 she became a U.S. citizen. However, her son also had, I think his interview was the day before hers or something, and his interview didn't go as well. She knew like immediately she was granted. She has no criminal history. Her only immigration violation was overstaying her initial B2 visa. Good moral character, all that stuff. Because remember, and this is why I want to talk about this case, when you apply for any immigration benefit, they can take your moral character into consideration. But with naturalization, it's a specific statutory requirement. So if they don't like you or think you're a bad person, they literally can deny it because it's all discretionary. Now, when you have arrests or convictions on your record, then you can make yourself a little harder. And it doesn't have to be in that statutory period. The statutory period is the date you file the application. Well, it kind of goes both ways, but it's the date you file the application, go back 5 years. That's part of the statutory period. The other part is that it then ends up continuing and basically until you are a U.S. citizen. So you could have your oath ceremony tomorrow, get arrested for murder, you're not becoming a U.S. citizen. So good moral character, incredibly important. Now, her son, he's not a bad guy. I've met him several times. I really like him. But he got arrested a lot for smoking weed, not drug dealing or trafficking or selling or distributing, just possession, straight up possession. And I think he had about 5, not even convictions, because they were usually dismissed eventually, but like 5 of these within the statutory period. Where actually at this point it was 4. And we had a nice long talk with him and his mom, and we said, look, you can apply now, even though this 5 years they're going to be looking at. It's possible they're going to deny it, but the fact is that it all shows what's called an ACD, or adjourned in contemplation of dismissal. You weren't convicted, you didn't go to jail or nothing like that. They were all the most minor at the time in New York marijuana offense, which was not even a misdemeanor. So we said to him, it's a toss-up. It's up to you, because it's very possible they'll grant it, but it's also possible they won't. If they don't, here's the downside. You're going to have to wait to apply again. Now, we didn't have to wait forever to apply again, but I'll get to that in a second. So we file the application, goes to the interview, and then we find out that at the interview that he got arrested again for marijuana possession. And that's what put the nail in the coffin, because it did seem like it was going well and that he had a good chance of granting it, because they saw that all the arrests were kind of just dismissed, which, by the way, you don't need a conviction in order for immigration to deny you of something. So the fact that they saw marijuana, they can give him a hard time. So it's very, very important, if you're in a criminal case, and you're not a U.S. citizen, you consult also with an immigration lawyer, so that you make sure that nothing you say or do is going to hurt you. You might end up, pleading, getting a suspended sentence and not even pleading guilty. But if the facts in your case say like you had cocaine, well, you might be making yourself a huge problem. So, side note, make sure you check on that. So the fact that he got arrested again was what the problem was. They ended up denying it. The reason they cited was that he was still on probation during the statutory period. They're using the term probation lightly, I would say, or loosely in this context. He wasn't. Adjourned in contemplation of dismissal in New York isn't probation. It's more like it's a suspended sentence. It's like you don't have to enter a plea, and as long as you don't commit any crimes before either a 6-month date or a 1 year date, then your crimes or your charges are dismissed and sealed, not expunged. Still have to tell immigration, even if expunged, even if sealed, even if dismissed. So basically, they said when the year is up for your ACD, and provided you completed it, then you'll be fine. And, like I said, it wasn't expected. The other offenses that he had that were dismissed, those were over with completely. It was the new one that because he's still waiting for that period of time to be over, that gave him the problem. So we waited until March of 2020 to apply again. And no more arrests, thankfully. And because of the pandemic, it ended up taking over a year for him to get another interview, which he had just had and got approved. Well, no, he had the interview, didn't get approved at the interview. Sorry, it had to go, of course, to a supervisor, because there was an issue. Whenever there's anything like any type of arrest or problem with an application, it goes to the supervisor. So it took a few weeks. We finally got the answer. And it shows you how wait times can shift. Now, I blame the pandemic for the difference in wait time, but the truth is, even without the pandemic, it wouldn't have surprised me if, they went from 6 months to a year suddenly. Just a side note on processing times. Check out our last live Q&A on immigration. Why is my immigration application taking so long? If you want more information on processing times, and that is also on our Facebook page, Instagram, YouTube as well. So, point is, a couple of things here that we want to take away. Number one, just because, before I even get to that, before I get to the summary, I want to make one note. Anyone living in New York right now, or where my client is from in Nassau County, where they actually, I think it was 2 years ago, they passed a law to expunge all these records for possession of marijuana. And in New York, of course, we know that the recreational marijuana law was just passed, and right now in New York, it is not it is completely legal to possess marijuana, not sell, possess. So you might be thinking, well, why does any of this matter? Why am I even talking about this? It's not illegal anymore. Well, it is still illegal on a federal level. That's number one. It's still a controlled substance. If you try to board a plane with it, you're probably going to get arrested. If you get caught at the border with it, you're going to get arrested. But point is, even though it's legal on the state level, it's not on the federal level. And as I earlier said, you don't need a conviction to have an immigration problem. And the expungement that I spoke of, that was automatic, and New York City is doing the same. I think all New York State now is doing it since that new law was passed a few weeks ago. Even though it expunged everyone's unlawful possession of marijuana without you having to lift a finger, it doesn't mean that it didn't happen. It doesn't mean immigration won't know if you don't tell them. So therefore, it means you still have to tell immigration and explain it. And yes, they can actually still use it against you. Marijuana possession, I do think the tide's turning a little bit on it, on how they're viewing it. And maybe the officers in New York were a little more lenient than in a state where it's still illegal. I'm not sure, but that's what it is. So even though it was expunged, even if he got a pardon from the president for it, it actually would literally still could affect his immigration. So, like I said, the important things to take away here. Number one, the mere fact that you have a bunch of arrests for minor things doesn't preclude you from getting a green card, doesn't preclude you from getting your citizenship. It's incredibly important you speak to an immigration attorney in those situations before you file to make sure you're not going to have any problems and that things are explained properly to avoid potential problems. The second thing is, just because you get denied once because of good moral character does not mean you're going to get denied again. And like I said, he didn't wait 5 years. Hi, Mensa. How you doing? Want a shout out from Instagram. So it doesn't mean you can't apply again, and it doesn't mean you won't get approved. Again, you want to make sure, because there are times where you have to wait the full 5 years depending on why you were denied. In his case, we didn't have to. Otherwise, the worst case scenario is they deny it again and he has to apply again in 5 more years, which is a pain in the butt. So make sure before you reapply, you're eligible to reapply. And finally, well, this is kind of a two-parter. When you look at the good moral character period, like I said, for the 5 years, if you're applying based on 5 years of being a permanent resident, the date you file, go back 5 years, and then go forward until you become a citizen. And then same thing with the 3 years, but you're going back 3 years instead of 5 years, and also goes all the way up to you becoming a citizen. Now, what that means, thank you, Mensa. I'm glad that she says, I can't see if you're a female or a male, I apologize. Mensa likes what I am doing. I'm glad that you enjoy it. I'm glad, I hope everybody's finding this helpful. What was I saying? Oh yeah, so the period of time outside of that 5-year period for good moral character, or 3-year period, still is relevant, and it still can hurt you if you did something really bad. It's not going to be forgotten. You still have to If you've had an arrest 30 years ago, you still have to tell them. But it makes it a lot easier. Okay, Mensa's a male. Well, thank you for joining, Mensa. So I'm going to wrap up now. If you guys have any other questions, you can let me know. The last point I wanted to make about the good moral character period was once you apply for naturalization, it is not just backwards looking, it is also forwards looking. So just like this client, if you get in trouble with the law in any way, shape, or form between the time you file your application and the time that you would end up going for your oath ceremony, you might have a problem. So I suggest being on your best behavior. I suggest you always be on your best behavior, but especially when you're waiting for naturalization, because the slightest thing they see, they're going to deny you because they know you can reapply again. And obviously you don't want to be in a situation where what you did is so bad that you end up getting put in removal proceedings because you violated the terms of your green card. Naturalization applications are a very big way people get caught up in things like that. So my best advice, do not apply for anything until you consult with a lawyer, especially if you have any type of criminal history or arrests. And last but not least, do not forget to not be afraid of reapplying. Again, check your eligibility, check with an attorney before you do it, but because you don't want to waste your money and time. But just because something's denied once does not mean again. Well, that is all today for notable approvals. A big reminder, tomorrow night at 9 p.m. Eastern time or 6 p.m. Pacific time, we will be having episode 6 of Are You Smarter Than a Naturalized Citizen? 2 more immigration attorneys are going head to head to see who can pass a naturalization test first. It's a lot of fun. If you are watching this and you're studying for your naturalization test, or you're thinking of taking it, then I highly recommend that you watch it. And if you're just curious what's on the test, it's a good time. And don't forget to like us and follow us on Facebook and Twitter, YouTube. I mean, we're on Twitter, but I don't use it as much. And Instagram, so that you don't miss another of our lives. I have a quick question. I want to send credit card statements, but realize I purchased hemp products, CBD. Okay, Jorge, I'm not really sure what you're talking about. I think that it's not relevant to what we're talking about right here, but if you shoot me an email, my email at the bottom of the screen, explain to me your problem, I'll see what we can do to help you. All right, everyone, thanks for watching and have a great day.